Second Amendment, bearing arms, a well-regulated militias being necessary to the security of a free state, the right of the people to keep and bear arms should not be infringed. In general, for over 200 years, despite extensive debate and much legislative actions with respect to regulation of the purpose, possessions, and transportation of firearms, as well as proposals to substantially counter ownership of firearms, there was no definitive resolutions by the Court of Justice what right the Second Amendment protects. The Second Amendment is naturally divided into two parts. It prefatory clauses, a well-regulated militia being necessary to the security of a free state, and it operative clauses, the right of the people to keep and bear arms should not be infringed. To perhaps oversimplify the opposite argument, the state right, the side emphasizing the importance of the prefatory clauses, argue that the purpose of the clauses was to protect the state in their authorities to maintain farmers organizing militia units. The individual right, this emphasizes the operative clauses so that individuals will be protected in the ownership, possession, and transportation of firearms. Whenever the amendment means it was seen as a bar only to federal action, not state or private restraints. One of the Second Amendment cases that the court has heard, and until recently the only case challenging a congressional enactment seeming to affirm individual protection, but only in the context of the maintenance of a militia or other such public force. In United States, visit Millers, the court subtained a status requiring legislations under the National Firearm Act of serving of shotguns. After reciting the original provisions of the Constitution dealing with the militias, the court observes that with obvious purpose to assure the constitutional continuation and refers possibles the effectiveness of such forces, the declaration and guarantees of the Second Amendment were made. It must be interpreted with that end in view. The significance of the militias, the court continues, was that it was composed of civilians, primarily soldiers or occasion. It was upon this force that the state could rely for defenses and securities of the laws, on a force that comprises all men physically capable of acting in concert from the common defense, who, when calling for service, we are expected to appear bearing arms supplied by the servants and of the kind in common use at the time. Therefore, in the absence of any evidence tending to show that possession of use of a shotgun having a barrier of less than 18 inches in length at this time has some reasonable relationship to the preservation of efficiencies of a well-regulated militia. we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. Certainly, it is not within judicial notice that these weapons is any part of the ordinary military's requirement or that its use could contribute to the common defense. After that decision, Congress places greater limitations on the receipt, possession and transportation of firearms, and proposals for national registration or prohibition of firearms altogether have been made. Miller, however, should lightly light on the validities of such proposals, pointing out that interest in the characters of the Second Amendment right has recently burgeoned. Justice Thomas concurrence in the court invalidations on other grounds of the Biden's Handgun Violence Prevention Act, questioning whether the Second Amendment bears federal regulation of gun sales, and suggested that the court might determine at some future date whether Justice Stories was correct, that the right to bear arms has justly been considered as the palladiums of the liberties of a republic. It was not until 2008 that the Supreme Court definitively come down on the side of an individual's right, daring rely on new scholarship regarding the origins of the amendment. The court in District of Columbia visit Ellis, confirming that what had been a growing consensus of legal scholars, through that the right of the Second Amendment are orders to individuals. The court reaches this conclusion after a textual analysis of the amendment, an examination of the historical use of prefatory phrases in statutes, and a detailed exploration of the 18th century's meanings of phrases found in the amendments. Although accepted that the historical and contemporaneous use of the phrases keep and bear arms after arising in connection with malicious activities, the court noted that its use was not limited to those instances. Further, the court found that the prisons were regulated militias, referring not to formally organized state or federal militia, but to the poor of able-bodied men who were available for conscription. Finally, the court reviewing contemporaneous state restitution, post-enactment commentaries, and subsequent cases laws to conclude that the purpose of the right to keep and bear arms extended beyond the context of militia service to include self-defense. Using these individual rights theories, the court struck down a District of Columbia law that bans virtually all handguns and required that any other type of firearm in a home be disabled or banned by a frigate's lock at all times. The court rejects the argument that handguns could be banned as long as other guns, such as long guns, were available, noting that for a variety of reasons, handguns are the most popular weapon chosen by America for self-defense in the home. Similarly, the requirement that all firearms be readily inoperable at all times was found to limit the clear, lawful purpose of self-defense. However, the court specifically stated albeit in dictates that the Second Amendment did not limit prohibitions on the possession of firearms by fellows and the mentally penalties for carrying firearms in schools and government buildings. All laws regulated the sale of guns. The court also noted that there was a historical tradition of prohibiting the carry of dangerous and unusual weapons that will not be affected by its decision. The court, however, declined to establish the standards by which future gun regulation will be evaluated. And more importantly, because the District of Columbia is a federal enclave, the court did not have occasion to address whether it will reconsider its previous decision that the Second Amendment does not apply to the state. The latter issues was addressed in McDonald's v. Chicago's, where pluralities of the court overturning previous proceedings found that the Second Amendment is incorporated through the 14th Amendment and is thus enforceable against the state. Relevant to this question, the court examining whether the right to keep and bear arms is fundamental to our scheme of ordinary liberties or deeply rooted in this nation's history and tradition. The court relies on historical analysis set forth previously in Hellas, noted the English common law root of the right to keep arms for self-defense and the importance of the right to the American colonies, the drafting of the Constitution, and the state as a bulwark against overreaching federal authorities. Noting that by the 1850 the perceiving threat that the national government would disarm the citizens had largely federal, the court suggested that the right to keep and bear arms become valid principally for purpose of self-defense, so that the passage of further 14th Amendment in part was intended to protect the right of ex-slaves to keep and bear arms. While it was argued by the dissent that this protection would most logically be provided by the equal protection clauses, not by the due process clauses, the priorities also found enough violence of the existing concern regarding the treatment of blacks by the state militias to conclude that the right to bear arms was also intended to protect against generally applicable state regulation. Thank you. God bless the United States of America. Thank you. Have a nice day.